you. Please be seated. Good morning, everybody. Welcome back. Hopefully everybody had a good weekend, all things considered. We are going to go on the record. It is Monday, March 23rd, 2026. This is State of Utah versus Megan Sundwall, case 251401132. Council, let's talk about instructions. I appreciate the efforts that have gone into this over what was probably a long weekend. It sounds like you've got, or it looks like you've got a lot of the things narrowed.
Yes, Judge, and actually I think we've narrowed it even further. The state originally was planning on arguing the lesser of murder be included. I think that we have decided that we don't believe that's necessary. So I think that...
So we can pull that as a lesser included.
Yes, and,
okay.
And then I believe the parties are in agreement that the lesser included of reckless manslaughter can also be pulled. So any definition of recklessness can also be pulled. I think that there may be at least two references to defining recklessness in the court's instructions.
Thank you. Is that your understanding, Mr. Williams?
Yes.
Thank you. Any other stipulations before I have questions for both of you?
I think we generally stipulate, we found a few just minor little typos that if we go page by page, I can point them out. Like there was a missing of or two or something like that, but I'm happy to point.
Perfect. That will be helpful.
And then I think our main disagreements today are Scott submitted yesterday proposed language for the lack of duty instruction. We have arguments that I believe first such an instruction is not necessary, but if the court finds that it is, we proposed more language that I would argue includes more of the context and is appropriate given the definitions of causation in this case. And then also the state would argue in its proposed instructions, we included a condition of peril instruction. We would argue that that be placed back in. I think we also would like a instruction on intervening cause. I know that Melanie Haney, I believe, is maybe who is helping the court out, and she had some comments. We talked to folks in our admin that worked in appellate law, and he believed that having a definition of intervening cause is necessary because it's part of proximate cause. And so on appeal, if proximate cause is part of it and then intervening, it references intervening cause, and if that's not defined, that may run into some problems. That sounded very convoluted. I hope the court understands what I'm saying there.
So, and we're going to get to that.
Yeah, and we can go page by page.
So let me open up. Are we going to work off your proposed instructions that had the highlights and stuff?
Sure.
Okay, great. Thank you.
So the first question I have, and this is for the state, and you've hit on this, Ms. Hunt, is what is your theory of an intervening cause, and is there a basis for it? You're going to hit on that. I'll get a chance to respond. Another question, going to causation, is a question specifically is, can we just use the ordinary meaning of causation? Do we need a specific definition? Is there case law that says that we need a specific definition? And if so, what is it? And then a question for Mr. Williams on the no duty to provide aid. The question I have for you when we get there is there a case supporting this? Is there any precedent that you can point to when we get there? Let's start with the intervening cause issue, and is there a basis for that, and where are we going to where are we gonna go with that, Ms. Hunt? If you wanna give me some more detail.
Yeah, and I don't know that there are facts. I think the reason that we're arguing it should be included is just that under definition of proximate cause, it refers to an intervening cause, perhaps interrupting the chain of events. I don't know that there are any facts here that would support that there is an intervening cause, but I think just for appeal purposes, our admin thought it appropriate to still instruct upon it just because it's referred to in proximate cause, but actually at looking in your instructions and what Melanie seems to have kind of reduced down under the causation, it might not be necessary. I don't know if Ms. Thomas has specific thoughts on that. Okay, I think we may be fine with what Ms. Haney, reduced the causation to.
Okay.
But I would like to add in condition of peril because I do think facts support condition of peril. A condition of peril instruction, which we provided, and I can resend it to you, but which the state provided in its original proposed instructions.
Mr. Williams, as it relates to the condition of peril instruction request.
I'm sorry, you're all right. I don't know why we would have a condition of peril request. If I could see the instruction, I either missed it or we hadn't turned to that in the proposed instruction by the state. I worked mainly off the court's instructions because I expected that when you put that together, that was what you thought after seeing the proposed instructions by the state. So I might need a minute. Why would we need a condition of peril instruction?
And that was my question for the state. Okay.
And I'm happy to address that now.
Go ahead.
And I can email this to everybody, but in the state's original proposed instructions, the condition of peril says, where an individual by her wrongful conduct created a condition of peril, her act can properly be found to be the proximate cause of a resulting injury or death. A person created a condition of peril when she creates a condition that exposes another to the risk of being injured or that imperils or endangers another. And the state, the cases relied upon for that is State v. Hallett, that's 619 P2D 335, and also State v. Boss, which is 127 P3D 1236. And I believe one of those cases is the facts in one of those cases about condition of peril is somebody knocked over a stop sign and then left the scene without fixing the stop sign, and then ultimately a crash resulted. And I'm forgetting now if a death happened, but I think maybe so. And so the person that knocked over the stop sign created the condition such that it was foreseeable and the proximate cause that a crash may happen. And I believe that person was correctly found guilty of manslaughter in that situation. And so here I think the facts, many of the facts do support, and I know that there could be many theories of causation here, and the state does intend to argue a few of them. But one of them is that Ms. Sundwall created such a condition of peril, and at that point, if the jury finds that it's a proximate cause to the injury resulting in death, I think that we're entitled to have them instructed upon that.
Anything else, Mr. Williams?
I don't know how or why the evidence could possibly lead to an argument that Ms. Sundwall created a condition of peril. The state hasn't articulated it, they've just asserted it.
Sorry, and I'm gonna email that language right now so we can all.
What's your first case?
State v. Hallett, 619 P2D 335, and also State v. Boss, 127 P3D 1236. Hallett.
I'll give you a chance to look at that, Mr. Williams, before we move on. Mr. Williams, did you receive that yet?
It was included in the original instructions I sent to you before trial. I believe I just sent another, maybe I didn't include the other.
Well, I can go find it if you'd like a condition of failure, but
I'm sorry, I didn't. That's okay.
I mean, I'm looking at the proposed language of the two cases. They just, first of all, they're not about jury instructions. They almost don't even mention condition of peril, but they're both negligent homicide cases, and part of it is tied to that, to the notion of can you be negligent and do something that creates, I mean, I would ask the state, the court to have the state specifically articulate what could possibly in this case be creating a condition of peril. The entire theory is, as I see it, maybe they've got to propose something in closing that I haven't seen for 2 weeks, but would be that an act was committed inside a room where the decedent set a stage, introduced the glucometer, clearly took a reading before Ms. Sundwall entered, texted in connection with this plan that she was going to preload some syringes, and died by overdose of insulin. What condition of peril the facts could even warrant this, assuming it's a real thing? Again, these cases don't even cite to jury instructions given in the two cases. They only cite to both of them are criminal negligence cases, one of them with strong dissent. That's Hallett.
And I've reviewed Hallett. Ms. Hunt, that gets back to my original question, is what's the theory?
I think that's multifold, and I'll start at the beginning. So I think based on the evidence submitted, the jury could rationally find that the defendant caused the victim's death through the creation and control of a lethal medical condition, which includes planning, facilitation, monitoring of deteriorating blood glucose levels, and interfering with timely medical intervention. So even if the jury does not find beyond a reasonable doubt that Ms. Sundwall personally injected the substance, she did a number of affirmative acts that contributed to the cause. And then more specifically, Mr. Williams has referenced text that Kacee was pre-filling syringes. The state also introduced evidence that the night before, around I believe 9:48 p.m. on August 11th, Kacee Terry Googles, "Can I inject myself with saline?" It's going to be one of the state's theories that she and part of defense's own expert went to this parasuicidal behavior, where somebody does not intend to die but sets up situations such that they are, manufacturing a situation that looks like that. Part of the state's theory, or one of the state's theories, and again, the jury doesn't have to be unanimous as to the theory, only unanimous as to the cause, whether Ms. Sundwall caused the death. But part of the state's theory is that, consistent with parasuicidal behavior and consistent with Ms. Terry's history of fabricating medical events, even having to go to the ER and pretending that she was getting chemo and cancer treatment, that she does go to great lengths to look like things are happening that are not medically accurate. And one of our theories is that she prepared those syringes that were to be used and filled them with saline. And the defendant came over, and at some point, the defendant became wise to the fact that those syringes did not have insulin in them, and the defendant filled some other syringe with insulin. And then how that got administered, I think it can have been a number of ways, all of which I think lead ultimately to Ms. Sundwall being the cause. We know that promethazine, opioids, and Xanax were found in Ms. Terry's system. And we know that Ms. Sundwall herself said, "Do you want to take promethazine so you're asleep while this is happening?" when the last text she sent. So perhaps Ms. Terry fell asleep thinking that she was safe enough to do so, that she had pre-filled the syringes and that they were full of saline and that she was in no danger. And then she could carry on this lie that she had been telling of, "Look, nothing works on me. Insulin, I tried 4 bottles, I tried 9 vials, I'm getting the surgery so my body can accept medications. Look, nothing works." Or, she could not have been asleep, and perhaps the defendant caught her off guard and injected her with insulin. Or, especially, and this is where the condition of peril comes in and where the substantial factor and causation being more nuanced, which I do think that the court's instruction captures, is that the saline swap, the syringe swap that I think the evidence rationally supports that Ms. Sundwall could have engaged in, she could have swapped a syringe that had saline, put insulin in it, and handed it to Ms. Terry herself. Ms. Terry could have been the one that actually injected herself with that, believing it was saline. But at that point, the defendant has instigated a condition of peril, which has proximate cause and foreseeability, that the insulin in that syringe was going to kill Ms. Terry. And facts and evidence, including the defendant's own expert about parasuicidal behavior, all support that. And I think a jury's entitled to hear about that, and the state's entitled to argue it because facts all support that.
Anything else, Mr. Williams?
Your Honor, Mr. Hancock's discussion of notions of suicide and the relationship and stuff in this case isn't evidence presented in connection with what happened in the room. I don't think they're entitled to these sorts of instructions and arguments just on wild speculation. The government has the requirement to present some sort of evidence. I granted there's a dearth of it for them in a variety of ways in terms of what happened in the room and what act. I mean, all of these theories, aggravated murder and aiding, require an act. And that's what the case is about. An act of just some wild theory that somehow Ms. Sundwall may have drawn up some insulin and so that Ms. Terry would take it and die, then that's covered. That doesn't create a condition of peril. That'd be aiding. That might be murder. These condition of peril notions is when you don't act intentionally. That's why the two cases you have are about negligence. It's when you don't intend an act, but by doing something negligently, or maybe even recklessly, you create some condition where you're criminally liable. Outside of recklessness and negligence, there's just no concept of condition of peril because you have to intentionally and knowingly cause the death. That's covered. Even by those arguments, you have to intend with knowledge that filling a syringe on premises was aiding or murder.
Thank you. Ms. Hunt?
Agreed, and I think we're talking less about the mental state, although obviously if Ms. Sundwall is filling up a syringe with insulin and either administering it herself, injecting it herself into Ms. Terry or handing it to Ms. Terry to inject, it obviously would be intentionally or knowingly leading to the death of Ms. Terry, given the information we know about insulin. But it goes primarily to causation, and I do not want the jury to have any confusion here. There is a scenario supported by facts and evidence where Ms. Sundwall does not have to have been the one to inject Ms. Terry. Primarily this, she swapped syringes at some point, and Ms. Terry injected herself with something she believed to be saline, believed to be harmless, and ended up causing her death, and that is the condition of peril. I do think that causation, the but-for and the substantial factor, I think it does cover part of that, but I don't want any doubt in the jury's mind that that has to mean that Ms. Sundwall necessarily did the injection herself. And in fact, I think that aiding, if we're looking at particularly under the suicide instruction, aiding means the act of providing the physical means. Providing means to administer, prescribe, distribute, or dispense. Similarly, in the aggravating factor of ag murder, the poison one, I'm sorry, let me just find that so I read it correctly. The homicide was committed by means of the administration of any substance administered in a lethal amount, dosage, or quantity. Again, administration does not necessarily mean there, and it's not defined, and so the jury can use the ordinary definition. It does not require Ms. Sundwall to be the one to have physically injected it herself. And I guess this is a scenario that I can liken it to. If you're poisoning somebody's food or somebody's drink, you can poison the material, you can put poison in the drink, you can put poison in the food, and then, you know, whoever you're attempting to poison can come up and they're the one that actually eats it or drinks it. It doesn't have to be force-fed to them or forced down their throat. But no doubt that person would still be administering them poison because, you know, but for the poison being in there, they wouldn't have died. And if they knew the poison was in there, they wouldn't have eaten the food or drank the drink. So I think that administration is broader than Ms. Sundwall having to be the one that injected Ms. Terry. And I think that an ample amount of evidence here supports that. Why would Ms. Terry Google, is it okay to inject myself with saline the night before she knows that Ms. Sundwall is coming over with the goal, with Ms. Sundwall's goal at least, and perhaps Ms. Terry's at least plan of faking it or something. The goal that Ms. Sundwall has is that Ms. Terry ends up dead. And so I think there's ample evidence, and the state should be able to argue every theory supported by the evidence, and whether the jury believes that or not, that's the jury's province.
Thank you. Let's move on to Mr. Williams, your no duty to provide aid instruction. Walk me through that.
Yeah, the state throughout, Your Honor, the entirety of this litigation has told me they agree that instruction of no duty to aid would be appropriate. And even the response, which is the only communication I got over the weekend, last night, doesn't say they object. It just says they would like different language. The state didn't provide any. I think it's important to have a no duty to aid. Gosh, in this case, can you imagine any more important one? Because it's not the same every jurisdiction. In Utah, there's this so every jurisdiction isn't the same. People might have a mistaken notion about duty to aid. And so we simply let them know that in Utah, the law is there's no duty to aid. And then we have the consent law in Utah that indicates that if you do, you'll be free from, prosecution or liability if you do so, and you do so in a way that's negligently or otherwise problematic.
What do you think of the state's proposed language on the no duty to aid, their proposal?
Did I miss it?
I'm sorry, I did send it this morning.
I don't read my emails while I drive. So
Go ahead and look at that, and we can discuss.
I'm not sure. Are we only talking of, I would object to the second paragraph. I mean, that's just a restatement of the condition of peril. I don't think if we're instructing them either, we would instruct them it's not ordinarily required to provide medical assistance to another person in distress. The reason ordinarily, well, I don't know where that comes from. State can say, I suppose, it doesn't come from any law that I've ever seen.
And that was my question originally too. Do we have any case law from either side supporting this?
No, Judge, and in fact, I believe that no duty to aid comes from civil common law, and I think it applies in situations where, and this is just an example off the top of my head, if I come upon somebody that is drowning in a pond or a lake or something, I don't have an affirmative duty, even though I may be able to jump in and try to save them. Similarly, you know, if Ms. Sundwall just came upon Ms. Terry having injected herself with insulin and is obviously struggling, she may not have a duty to provide care even though she is capable of it. But these facts, the evidence that has been presented to the jury, and what the state has been very careful about here, is this is not just, and nor have we framed it this way, and nor do we intend to, this is not a case of omission. This is not just, I came upon somebody and I have no duty to act here. The evidence supports that the defendant took a repeated series of affirmative acts to block aid, to put in motion the condition of peril under multiple theories. And so I think that all of this is covered. So number one, I would object to there being an instruction at all on it, because I think it's all covered in the causation instructions that the court has proposed. But if the court does think it's appropriate, I think that, you know, referencing, and I couldn't find a case either used in a criminal setting of a duty to aid or no duty to aid. The Good Samaritan law does not spell out that you have no duty to aid. It merely says that if you do step in a situation like that, and like Mr. Williams said, if you mess up, then you're not going to be subject to civil liability or you can't be sued. But here, what we have, and what Mr. Williams has presented is perhaps a technically correct view of what common law is understood to be, civil common law, but it's not complete, and it misleads the jury in this context, because here, I mean, if the jury is just told Megan Sundwall had no duty to help at all, then they are missing the law that supports, you know, situations where she would have some kind of duty, the condition of peril, where she would have caused the death by this string of affirmative acts. And the jury is, I think, entitled to, in context, if they're instructed on no duty to aid, they certainly ought to be instructed on situations where if the defendant has created the situation, if the defendant has set in motion affirmative acts that, or a condition of peril that are a substantial factor in the decedent's death, then in all fairness, it has to be taken together for them to understand, because otherwise, you know, they read no duty to aid and they think the analysis just stops there, and that's simply not the law. So number one, I would say we object to any instruction on this at all, because there is no criminal case law or context or criminal statute in Utah that implicates it. But number two, the facts are just so much more than what the no duty to aid contemplates.
Thank you. And I guess I'm really just concerned about your second sentence, as it just seems to reaffirm or meld with your other proposed condition of peril instruction.
Judge, I'm sorry, may I add to Ms. Hunt's
Go ahead.
I think Mr. Williams' language comes from, or his desire to include the no duty to aid comes from 78B-4-501, the Good Samaritan law. Subsection 2 of that provision explicitly limits that to rendering somebody who doesn't provide aid to liability for civil damage or penalties. In addition, that section also indicates that the person is liable if they are grossly negligent or caused the emergency. So there's no absolute duty or lack of duty to aid. It is A, it's civil rather than criminal, and B, there are limitations on that particular language that need to be provided if your Honor is going to include a no duty to aid instruction.
Thank you. Anything else, Mr. Williams, just for the record?
Sorry, yeah, I feel a little rope-a-dope on this because until this morning, the state had said they agree that such a basic common law does derive from common law. I can't imagine a case where it would apply more appropriately in the criminal context. Just that there's no criminal case law never means that, you know, that something's not available. We're not going to see a case like this ever on appeal, on a decision that matters, because this law even is going to be changed. But for this case and these facts, The jury shouldn't need to think that they can convict Ms. Sundwall, and there's been a lot of focus, indeed, upon the fact that Ms. Sundwall is a nurse, that Megan Sundwall had some sort of duty notwithstanding what Kacee did to herself, even if Ms. Sundwall didn't do anything to help, didn't aid, or didn't intentionally cause, that she somehow maybe still had a duty under the law to do something. For instance, of course, when Ms. Terry became unconscious. And that big gap, that multi-hour gap, should not be considered by the worry would be that the jury would think, well, if you didn't do something then, that must be criminal. So that's where this comes from, the specific facts of this case together with the common law, which the state hasn't denied, notion of no duty to act. It's just a basic statement that I put together. I didn't know last night there was a representation of view. The state might seek to modify the language of what I proposed. The Good Samaritan law, to the extent it's relevant at all, it'd be hard to figure that out, right? Because it just says if you do, then ... Which, by the way, clearly is law that suggests you didn't have to. Because it says that if you do, you can't be held liable. Why isn't it law that you don't have to? At any rate, and then also in subsection 2, it refers specifically to rendering emergency care. If we want to adopt that language somehow into the no duty, for instance, no duty to render, I think, emergency care. Let me see what my proposal was, but we can work that out in some sort of common language. No duty, in Utah there's no duty for a person to provide emergency care. That's the language from the Good Samaritan. Not the no duty part, but it's about rendering emergency care. So there it is in law.
Thank you.
And again, Judge, the state is not framing this as an omission case. There's ample evidence that the defendant took several steps of affirmative acts to either delay or prevent medical aid reaching Ms. Terry. And I think if the judge determines that a no duty to aid instruction is appropriate, then again, Mr. Williams' proposal is incomplete because it leaves out that if you create the condition of peril, if you set in motion all of these things, then it does become part of causation. And so I think that as Mr. Williams has proposed it is incomplete and misleading.
Thank you. Does anybody else in council, do either of you wish to make an additional record as to the issues we talked about on the contested instructions this morning? Before we get into the grammatical issues that we can easily fix.
Oh, I do think the state is entitled to under obstructing justice. I think the evidence supports 2 ways that happened. Number 1, the text message deletion of the topics that obviously are incriminating. And number 2, the lie to the police, that she has no idea what happened. The phone call later, at that, it shows that her story is evolving and that she knew that what Kacee, I think she says, I knew what she was doing and I didn't help. So that is obviously a lie to the police. I know Mr. Williams' argument was that was not the theory under which it was found over at preliminary hearing. I don't have the case law pulled up right before me, but I think there is case law that the state is not held to the theory found over at preliminary hearing, and in fact, both theories were presented at preliminary hearing, even if it's not the theory that the court deliberately found over upon. I know that we presented testimony from her interview that she had no idea what happened, and I know that we did play that phone call where she's saying something contradictory and that she knew what Kacee was doing and she didn't help her. And so I think the state is entitled to both theories. I think that Obviously, the jury would have to be unanimous as to at least one, but the evidence in the state's mind supports both.
Mr. Williams?
On the law, especially recent law, I believe it's clear that bind over has to be with specificity, as to if there are multiple wrongs, quite frankly, that's why they would have to have 2 counts. Absent 2 counts, there's 1 problem. And I can pull a transcript, again, of the argument on bind over. Or perhaps, Your Honor, maybe we could look at your order on bind over, but it's, in my position, it's been clear that this case proceeded to this point on obstruction by deleting text messages. By the way, that's exactly what the police officer says to her in the interview that the jury's going to hear. Deleting text message, that's obstruction of justice. That's what the officers, now, that doesn't limit the state to their arguments on the fact. I mean, those aren't the only facts that limit it, but on notice, due process notice, specificity law, I submit that the only specific bind over was on deletion, object to including any other theory or argument, or theory in jury instruction.
I think if the court is, in the event that the court is persuaded by Mr. Williams' argument there, I think then we do need one of those unanimity instructions that says that, you know, you may have heard that a crime happened more times than is charged. Then I think we would need it to be clear, and I'll make it clear in closing that if there is only one theory of obstructing submitted to the jury, deleting text, they obviously, and I'm going to talk about the fact that Ms. Sundwall lied to police, I think that we would need to add that instruction that you may have heard that a crime was committed more times than was charged. You need to be unanimous about the activity that accomplishes or satisfies that element.
Any other record, counsel, you wish to make?
I don't believe so on that. I've made my argument. I hope I have made the record clear that there should only be that count, that argument. I'm sorry, not argument, that position. Of course, an act of lying, there could be all sorts of other things that would be obstruction in a case. They're here for the state to argue as to intent and motive and all that. That doesn't mean we need any more instructions.
Thank you. Anything else?
Not specifically on the jury instructions, but I do want the record to be clear. Obviously, a number of different types of hearsay came in at trial, and I just wanted the record to be clear about the stipulations that counsel arrived at to get those things in. Some examples are, obviously, we let in the crime lab reports on the testing of the vial and the syringe. We did not have crime lab people come testify about that stuff. Mr. Williams had agreed to stipulate to chain of custody and anything essentially, and Mr. Williams, correct me if I'm wrong, but essentially anything that Detective Farney was aware that happened in the investigation, he stipulated to allow her to testify about those results. So I wanted that on the record too, because that was stipulation and agreement that the parties reached ahead of time.
Thank you. Anything else?
I'm not, just for the record, I'm not sure what stipulation means. What has happened is that in the interest of smooth trial, I made no objection to foundation for matters to allow the state to not have to present chain of custody. Because I stipulate to anything Farney said. Second of all, I mean, the record is clear on what objections were made or not made.
Thank you. Let's talk about the instructions. What needs to be fixed?
Let's see. In scrolling down, I think the first thing that is flagged is obviously, we need to take out defendant's testimony instruction.
That's been taken out.
Okay. The next one, an offense requires both conduct and mental state. I believe that we can take out recklessly. I don't know that any of we're not requesting a lesser of reckless manslaughter, and I don't believe any of the other counts include a reckless mind state.
And that, I've taken that out.
Okay. The state is okay on the next page with taking out motive instruction, because I think obviously the pecuniary gain aggravator under murder encapsulates motive, and similarly I think obstructing justice, there has to be at least some kind of degree of motive. You have to, one of the elements is, in order to hinder or prevent delay or something, the investigation. So I think that hints at a motive too. So I think that this motive instruction may be confusing to the jury given the facts of this case. So I think we're okay to delete that. I don't know if Mr. Williams' position on that for sure.
I think I indicated that we don't need a motive instruction.
Okay.
Thank you.
Not sure that we ever do, but it's given.
The next highlighted green section, I don't know why it's highlighted. It seems appropriate to me here. Maybe it was just, whether lessers were going to be included or something like that. I don't know if aiding suicide, she certainly wasn't charged with that. I don't know if that needs to be part of this instruction, since it is going to be included as an option for the jury to consider.
I'm sorry, Your Honor, I'm trying to keep track of which instructions.
Oh, sorry, I'm on defendant's charges. I believe it's page, I don't really have the right page numbers here for you.
Yeah, I don't have any page numbers either.
I think we've changed the name of aiding suicide manslaughter to just manslaughter, since that's the only theory. Is that your question?
No, I don't think, and also I think it would be clearer, I guess, once we get to that, or if we're arriving at that now. I think the state would prefer to call it aiding suicide rather than manslaughter. I think it's much clearer what we're talking about there if we call it aiding suicide. But in this instruction that lists defendant's charges, since aiding suicide or that form of manslaughter is going to be something the jury can consider, I don't know if we need to add it in here, but obviously she was not charged with that originally and has never been charged with that. Here, the defendant's charges here, sorry.
That's it. I'm having trouble going along. No charge.
And again, I'm not quite sure why it was highlighted. I don't know if Ms. Haney thought that if lessers are part of it, that they need to be included here. I don't know what the court's opinion on that is.
Defendant's charges instruction?
Yes.
I have no objection to just removing it. It's, at best, it's duplicate of the elements. And it is awkward in this particular case insofar as the state did not agree, didn't charge the aiding. So the aiding is better described as a lesser.
I think I agree with that. I would like to keep this instruction in though, because I think it does emphasize that the state has the burden of proving beyond a reasonable doubt all of the elements of the crimes charged. And I think that that's probably appropriate.
Thank you.
I think that's in the elements instruction. I'll submit it, but if it's modified, I'm not sure I understand what the proposed modification is.
I guess I'm not proposing a modification anymore. I'm just saying that the state is okay with including it, but I'll defer to the court.
Thank you. Next instruction.
The lesser included offenses, again, we're not seeking murder and reckless manslaughter. The only technically lesser here is the aiding suicide, and again, for clarity, the state would like to have it just called aiding suicide and not have the word manslaughter as part of that.
Any thoughts, Mr. Williams?
It's interesting, right? Because what's happens, the legislature realized that there's kind of a quirky problem there because they've now taken aiding and made it its own. But in this court, in this trial, it's titled manslaughter. Manslaughter colon in aiding suicide. I'm not sure we have a record if we don't put that in. If we don't make a reference to manslaughter, we haven't really articulated a crime as codified. Times appropriate to the statute. This is a manslaughter in the form of the prong of aiding. So the state has agreed the prong of recklessness need not be instructed in there. We're removing that, but it's manslaughter, subsection, aiding suicide. So I think it would be a little awkward legally not to call it that.
Thank you. Next instruction, or next issue.
Elements of count 1 aggravated murder. I believe this is where we found a little typo in the 4B aggravator. I think there was left out an of after administration. Does the court see that?
I do. Thank you.
Otherwise, the state has no issue with that.
Thank you. Next issue.
I think we can take out, as we stated, the lesser included of murder.
Do that.
Similarly, the lesser included of reckless manslaughter.
Thank you.
The next one down, the elements of lesser included of aiding suicide manslaughter. In the paragraph after the elements, we just added in, let me see if it's consistent with the others. So to compare, in count 1 aggravated murder, in that paragraph below the elements, it says, if every element has been proven beyond a reasonable doubt, then you must find the defendant guilty of aggravated murder. In aiding suicide, we added, because before it just said, if every element has been proven, you must find the defendant guilty. And we added of aiding suicide manslaughter. And then on the other hand, if you are not convinced, you must find the defendant not guilty of aiding suicide manslaughter, just to specify that of that charge. Does that make sense?
I think so. Mr. Williams.
Judge, did the court see my attachment?
We did.
Okay. So as you can see, I have a disagreement on how to articulate the elements, that they're awkward and I'm not sure correct with regard to the originally proposed the intentionality is aided, and then there's a knowledge component of the suicide, in my opinion. So in laying out the elements in the order that I have proposed is my record. In other words, just so the record's clear, the defendant, Sundwall 2, with knowledge that another individual intended to commit suicide or attempt to commit suicide. 3, intentionally aided the individual to commit suicide.
That might be clearer. I think the state was just taking directly from the statute, the language.
I tend to agree with the defendant's proposal.
Okay, I don't think the state has an objection to that. I think we just took from the statute, which it may be confusing what intentionally is modifying.
I think this makes it clear. Next issue?
Again, I think the next one that's highlighted is obstructing justice, and I think the arguments have been made to Your Honor about whether multiple ways of doing that is going to be allowed. If not, I think that we keep it as is. If you're going to allow the argument of lying to the police to be part of it, I think we need to add in that as subsection B and C, as Ms. Haney instructed, and then I think that her additional language on unanimity would be appropriate. And then again, if the court does not allow another theory of obstructing justice, I think that we probably do need to have that unanimity instruction that says you may have heard that a crime happened more times than was charged. And that's in Muji. I don't have it in front of me, but I think that that would be appropriate to add.
Thank you. Mr. Williams, any thoughts? Other than what we've already
No,
discussed?
there'd be multiple.
Okay.
I guess it would be because there are multiple deletions. In other words, that could be the only argument, is there were multiple deletions of text, right? And so my record's made in terms of the different forms of obstruction.
Next issue.
Again, depending on what the court decides on count 2, if there's allowed a second theory, the unanimity on count 2 instruction that Ms. Haney has highlighted, we've added in, so in the paragraph, you may not find Ms. Sundwall guilty on this count unless you unanimously agree that the prosecution has proven. We added beyond a reasonable doubt there that Megan Sundwall committed obstructing justice in at least one of the specific ways listed in the element 3 of instruction blank. And then at the very end, we added, if you find Ms. Sundwall guilty of obstructing justice, you must indicate your unanimous decision. We added in the language on the verdict form. And again, just trying to, for purposes of clarity.
And I made that change. Next issue.
Ms. Haney made a comment on the definition of intentionality. I can't speak for Mr. Williams. I do believe both counts are specific intent result crimes. So I think we agree with that. I think that instruction is fine. And then under the next instruction, definition of knowingly, we are taking out the lesser included offense of murder.
Your Honor, I don't think we have, for the record, a mens rea of knowingly here. Mens rea of aiding is intentionally acting. Then it says with knowledge that a person is. That is not, I submit, another mens rea in that statute. It's a question of fact. No, I would object. Well, I guess that's not true. Murder has intentionally and knowingly as a mens rea. So that's just an awkward aspect as I started to speak through it. Murder does.
Thank you.
Never mind, sorry.
Agreed. Aggravated murder does have intentionally or knowingly. Also, I would disagree with Mr. Williams that aiding suicide does not include. It clearly says with knowledge that another individual intends to commit suicide. I think the legislature clearly could have used other verbiage. They used knowledge, which is a recognized mental state. So I think it's appropriate to instruct the jury on what knowledge means there as well.
Next issue?
Taking out recklessly definition entirely, the court's probably already done that.
Thank you.
And then I think the next issue is getting to the causation. I think that the state is largely okay with what the court has presented, but again, the state would request a definition of condition of peril, and then I also think that just for completeness sake, we would like intervening cause to be defined because it's part of proximate cause, and then proximate cause, if condition of peril is included, it refers to proximate cause, which then in turn refers to intervening cause. So I think it would be potentially complicated on appeal if the jury doesn't have meanings for what those terms are.
Thank you, and I'll go back and make changes and come back with a ruling on those, so we're clear on the record.
And is it clear I object to that?
It is. Any other issues with the instructions, or I guess we'll need to modify the verdict form?
We just had again, I don't know that it's terribly material, but the verdict form instruction toward the very end, the last sentence is, remember, any response you give on the verdict form must be unanimous. We changed it to, remember, all responses you give on the verdict form must be unanimous, just because obviously there's going to be multiple.
I'll think about that. Anything else from either party?
I did come up with, I'm not sure if you've decided, of course, yet, whether you might give a sort of duty to aid, but in my proposal, one other alternative, since it's language straight from the Good Samaritan Act, in other words, statutory language, is after and to aid another person who, we perhaps could say, may otherwise require emergency care. That's the language from the Good Samaritan. So it's just a proposal.
Thank you. Anything else before I go back and make changes? Come back and make my ruling, and you'll get copies of everything.
This is, I can't point to any law, it's just not a way that I've seen it before, but on the verdict form, the list of, the first thing listed is not guilty, and then followed by guilty of, obviously we'll take out reckless manslaughter and murder, but I've just never seen it. I can understand certainly why the defense would want it in that order. I'm sure that you can understand why the state wants it in a different order, but I think it makes more sense to descend in the order of guilty to not guilty, because that's kind of the path that they're, later instructed on to follow the different, inquiry A or whatever. We think it makes more logical sense to list the guilty offenses first and then not guilty. It just, I think, provides a clearer path for them to what they have to do, but I'll submit on that.
We don't have any precedent for that. It's just an argument. Is that correct?
Yes.
Yeah, we have some precedent. The starting point is not guilty in this country.
Thank you. All right. I'll go back and make my changes. I'll come out and rule on the two main instructions that we had detailed argument on. The jury will
Excuse me.
be here in about 20 minutes. We'll get copies for them. You'll have copies. I'll give you a chance to review them, and then we'll get started.
Thank you, Your Honor.
Thank you all for your efforts. Be back in a moment.
All rise.